Welcome to the Four Corners 912 project discussion on rules of the game. For a country to exist peaceably as a unified people in the game of life, we all must be playing by the same rule. The rules for our country were established in the Constitution that was agreed upon to abide by. This was and is the supreme law of the land.
To follow the rules, you must know what they are. They are few and clear. We hope to help you all to better understand what the rules are, as we are looking to elect new representatives in local and state government offices next year.
They take an oath to uphold the constitutions of both the state and the United States.
What are they to uphold and protect?
We will begin this regular discussion beginning with the Bill of Rights, which is the first 10 amendments of the Constitution.
Welcome back to the rules of the game. Happy to have you today. Today we'll be talking about the 7th Amendment to the Constitution. To get us started, Bud, what is it?
In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. That's what it says.
Oh boy. To me, it's a lot of maybe mystery and confusion. In our courts, we just assume that we have a court and we have our jury trials. There has to be a history of all this. What is it?
Okay. Well, as we so often mention, the Constitution of 1787 is based in large part on the Declaration of Independence and the Bill of Particulars, which derive from the abuses of the English king and parliament. And so trial by jury had been long established in England as a right of the citizen. But during the lead up to our revolution, the British suspended that. They got away from picking a jury and started assigning these civil cases to the admiralty courts, which was trial by judge. They just didn't want the vagaries of a jury to mess with their predetermined outcome. And so, as we talked about in Amendments 4, 5, and 6, which dealt with criminal cases, the founders felt that we needed to deal with civil cases and correct that. And there was actually quite some interesting discussions during the convention about civil trials. And so they hammered around whether or not it was needed and whether or not how to do it and so forth and so on. And during that time, the states, which already pre-existed the Constitution, had already dealt with civil cases. I think it was 9 of the 13 states had already dealt with the guarantees of civil cases in their constitutions. So, again, it all devolved from the abuses of the British Crown against what is called the British common law of that time. And the common law is mentioned right in here twice. In suits at common law, according to the rules of the common law. There is discussion going on today as to what that means. What is common law? Is it the same thing as the pre-existing British common law? Or is it some other socially accepted common law? And the legal beagles still have not settled that question. We're not sure what common law in this means, because British common law was written, okay?
Right.
Common law was a little bit more informal. That's about the best I could figure out.
Well, where did, back up, when you talked about the abuses by the system, abuses by the British. What are we talking about, the abuses of the law?
Well, under British common law in civil cases, you were entitled to a jury trial, period.
Okay.
But the prosecutors and whomever and so forth didn't like the outcomes of juries. So they started assigning civil cases over to the admiralty courts, which were supposed to deal only with crimes on the high seas. And that's a judge only. That's not a jury trial in the old admiralty courts.
And that gets down to what I'm talking about. So what was happening is they didn't like the outcome of the jury.
Correct.
The juries were, and maybe not going along with, I think I'll call them bad laws that they were dealing with.
That was part of it. Yeah, they would nullify a law.
Okay.
There were cases where they did not nullify the law. They admitted, this is a jury, would admit that person committed that offense. That person is guilty of that offense. But we're not going to convict. Nothing wrong with the law. The law is the law. We maybe don't like it, but we can't overrule it. But we're just not going to convict. That's in criminal cases.
Yeah.
And so it's less clear in civil cases because you have two parties arguing over an issue. You don't have the state prosecuting somebody. You just have two citizens arguing over an issue. Now, the other civil case that is not mentioned here, excuse me, is in the sense of one citizen against the jurisdiction of another state. So that gets into another whole issue about how this applies, and the rules and the laws vary there. Like the $20 thing. In federal civil cases, which would be one citizen against the state of another or a citizen of another state, $20 guarantees you the right to a jury trial. There's no such provision in Colorado.
Okay.
In Colorado, you are entitled to a jury trial, period.
$20 or not?
Doesn't matter. Now, you can waive that. The parties can waive these provisions, but they both have to agree. But if one party or the other says, nope, it says $20, and by golly, I'm sticking to it. And there's never been a push to change that. To bring it up to date insofar as inflation or so forth. There's never been a strong push to change the $20 limit.
So we have a lot of civil cases here. Not all of them use juries. Is that right?
Sure, that's right.
So they waive that.
They waive their right.
But they have the right.
They have the right. And in Colorado, it's absolute. No limitation.
Do we still have abuses, you think?
Yeah, we do.
One of the things that, when we're looking at these things, one of the things that I think we need to remember is, again, we're looking at laws that if it's a valid law, it must be pursuant to the Constitution.
Correct.
And we have laws on the books that we feel quite sure are not pursuant to the Constitution.
Many, many.
Lots of them.
Many, many.
So when we go to trial, the jury can consider what's called nullification on the case because the law that is being charged, the person being charged, is not pursuant to the Constitution.
I would change one word that you used. You
Okay.
said they can. I would claim they must.
If they this gets down to where the jury needs to understand the Constitution.
Correct.
This is where we get back, and when we are dealing with elections of officers in our state and our county government, are they going to be passing laws and regulations that are not pursuant to the Constitution, that we're going to be charged in court?
Yeah, they can get away with it.
That's right.
There are many instances, modern instances, where during jury selection, somebody shows up with this in their pocket. Put the little Constitution right in the pocket there. That person is either immediately dismissed or the copy of the Constitution in their pocket is taken from them and removed from the courtroom.
That took place very recently with the Bundy situation in Nevada.
That is absolutely what I'm thinking of. You
Literally dismissed them.
dismiss those jurors because we can't have any constitutionalists on a jury. Now, what have we been calling these discussions? About the rules of the game. How would you like to have an umpire at a baseball game that didn't know what the rules were? Well, that's what a jury is. A jury's kind of an umpire. And we don't want them to know the rules? Give me a break. No wonder we're in a mess we're in.
True story. True story.
But the abuses of the Seventh Amendment are numerous and usually involve a judge claiming that the $20 thing doesn't really matter and I will hear the case, not a jury. And those cases, as far as I could tell, in every case has been overturned by the Supreme Court. You know, whoever's doing their arguing, they get it up to the Supreme Court. And the Supreme Court will turn it back down to the trial court and say, the Constitution says jury trial, you have a jury trial. Every case I could trace in a few minutes that I had, the Supreme Court said, Amendment 7, try again, Mr. Know-it-all Judge. So that's basically, I mean, Amendment 7 is short and sweet, and there's been very little actual controversy over it. That's the thing. Now, I mentioned admiralty law. In our federal system, we have criminal law, admiralty law, and civil law. And so admiralty law is addressed in Article 3 dealing with the court systems. And I mean, it's not detailed, but it does say, you know, the Supreme Court will deal with admiralty law, and then that's another whole batch of laws, separate and apart from criminal and civil. So that would make for some interesting reading. It would put you to sleep, I'm sure.
Would me.
So that's, I don't know, short and sweet, that's Amendment 7.
Main thing is we need to understand that we need to know what our rules are.
Correct.
We need to understand our Constitution, not just Amendment 7. Amendment 7 tells us to know the rules, rest of the rules.
Yeah, it does. Common law.
Understand what they are, and understand that when laws are passed, we need to examine them. This last legislature, we had laws passed in our own state that they had not looked at the Constitution, had not made laws that's pursuant to the Constitution, and so we have bad laws on the books.
Bad law.
And so there we are.
We'll see how the challenges go.
That's right. So
because they're going to try to get an ignorant jury.
yeah, true story. Well, there we have the Seventh Amendment.
Piece of cake.
Easy time. Next time, we'll look at the Eighth, huh?
Should be another easy one. Excessive penalties, excessive fines, and all that there kind of stuff. Shouldn't be too hard.
See you next time.